My name's Ken Carlson. I'm an attorney specializing in landlord-tenant law since 1980. This free legal consultation is brought to you by my caltenantlaw.com website. Today, we're talking about an eviction for other than something that you've done. More specifically, we're talking about how you win an eviction that's based upon those grounds. In the earlier consultations, I described evictions based upon non-payment of rent, for violating a term of the lease, causing a nuisance, subleasing, and foreclosure. Even though you've done nothing wrong and the landlord does not accuse you of anything, you can still be evicted for other reasons. The simplest among these is where you're in a month-to-month tenancy that you can terminate by a 30-day notice. You gave that notice, but then didn't move because circumstances changed. Your job transfer fell through, the new place isn't available yet, your application was rejected, your relationship broke up, any number of things. The landlord was planning on your moving, may have advertised the vacancy or signed a lease with the new tenants. Your not moving as promised is a valid ground for an eviction case to enforce your notice. Maybe now you just want to stay, or you need more time. In most cases, the landlord can just agree to let you stay. But if you live in a rent-controlled unit, the landlord will probably insist on your moving because he can jack up the rent for the new tenant. The landlord may have already signed up the new tenant and wants to avoid a legal tangle over that. The landlord may have seized on your notice as a golden opportunity to get you out where he had no other grounds to evict you. You have to defend an unlawful detainer action against you. You can still win an eviction like this. The easy way is if the landlord accepts rent for a period of time after you promise to move. That waives the notice, canceling your move, and reinstates your tenancy. It can be as easy as paying for an extra week or so after you said you would leave. He wants the money, so he takes it, perhaps not realizing that he just undid what he was trying to do. You win that case. Another way is on technicalities, that you didn't give proper notice. Just like the landlord has to give you a written notice of termination, giving a specific date without conditions, that same applies to you. If you said, I'm thinking about moving by the end of the month, that's not a commitment to the date. If you said, well, if I get that job transfer, I'll be out of here by the 15th, that's conditional. If you said, I'll be out of here in 20 days, that's not the required 30 days. You didn't give legal notice, so you didn't properly terminate the tenancy. You win the case because you didn't legally terminate the tenancy by your notice. Beyond the content of your notice, it can be invalid because you didn't give it properly. It has to be on paper, handed to the landlord, or handed to someone like the manager and mailed to the landlord. If you gave notice by phone, text, or email, it didn't count because you didn't serve the notice as required in Code of Civil Procedure 1162. If you only gave a copy to the manager but didn't mail a second copy to the landlord, it didn't count. You win the case because you didn't terminate the tenancy with proper service of the notice as required by law, so your notice was void and can't be enforced by an eviction. If you have roommates and you give notice to the landlord that you personally are leaving, it does not terminate the tenancy for the remaining roommates. The tenancy continues, minus one occupant. There is no liability for any of the roommates because the tenancy was not terminated, and there is no legal termination notice to enforce. You win that case. The next category of eviction, not based on your doing something wrong, has come to be known as a no-fault eviction. Those are, 1, the landlord wants to sell the house or condo that you're living in or take it off the market. 2, the landlord wants to move in themselves or move in a family member. And 3, the landlord wants to demolish or do some major construction of the building that requires you to go. There are other reasons like condemnation, red tagging, and destruction, such as by fire or flood, but these three are probably like yours. Each of these has a logical and fair purpose, but because they rely on future plans, they are the devil's playground for abuse by the landlord. The landlord thinks you won't question or investigate his claims, and once you're out, he changes his mind and charges a higher rent from the new tenant. Some cities and counties have protections to avoid abuses like these, but most cities and counties just leave it to you and the courts. Let's examine each of these. What is known as California's Ellis Act permits a landlord to stop renting and just sell the property itself. No doubt the realtors' lobby had a hand in passing that law. The landlord plans to flood the place with realtors and finally make repairs that you had requested and upgrades, all to get a top dollar sale price. Your moving out doesn't have to be a hostile situation. You may qualify to buy the property and save the landlord huge real estate commissions. The landlord might agree to let you keep renting until escrow is about to close to get the money from rent up until then. You can agree to permit some construction or repairs while you're there and cooperate in showing the property. There is another free consultation on that topic. However, here we're focusing on the eviction itself. The Ellis Act prohibits cities and counties from preventing an eviction to sell or stop renting, but laws can still be made by those cities and counties to reduce the hardship of moving for the tenants. Even cities without rent control may still have a just cause eviction ordinance imposing conditions on eviction to sell the property. It may require the landlord to pay the tenant relocation assistance money, to give more time to move, provide special considerations for disabled or elderly tenants, provide help in finding a new place, and other things. There are a lot of technicalities. For example, the cities of Los Angeles and Santa Monica require special procedures for the eviction and require the landlord to pay the tenant's relocation assistance of $10,000 to $32,000 to help with the move. The landlord is making so much money selling the property that paying relocation assistance to help the tenant is well worth it. If you are protected by these local laws and the landlord did not comply with one of those terms, you win the case. If you're not in one of those protected cities, you might have help under the Tenant Protection Act of 2019, the TPA. The TPA applies to you if the building is at least 15 years old and you have been a tenant for at least 1 year. Within those two factors, the TPA applies to a house or condo unless a special notice required by the TPA saying that the TPA does not apply is not stated in the lease itself. Hardly any leases have it, so the TPA probably applies to you. It's a very complicated law, riddled with exceptions. For now, assume that it applies. Under the TPA, you get the same 60-day notice of termination you would normally get after living there for at least a year, but with a big difference. That notice has to also identify the reason for eviction, tell you that you are entitled to relocation assistance of at least 1 month's rent, and identify how you are getting it. That payment can be made by either waiving the last month's rent or by paying that amount within 15 days after you got the 60-day notice. That money is separate from your security deposit, by the way. If your notice is missing any of that information, or you don't get the full relocation assistance, you win that case. The sale of the property during your lease does not terminate your lease, with the very rare exception that your lease expressly says that it does. Some landlords have the misunderstanding that it does. If your landlord sells the property, you just have a new landlord to whom you pay the rent and who owes you the security deposit if you didn't get it back from the original landlord. You don't have to agree to rent the premises from the new landlord, like the landlord has to agree to your having another tenant take over your lease. If the landlord tries to evict you because he sold the property during your lease and you didn't leave, you win that case. Even if you have neither local protections nor the TPA to help you, you can still win the case if the landlord accepts rent from you for a period of time after the notice expires. The legal term waive means to give up a right. In this case, it would be the landlord giving up the right to continue evicting you based upon the notice of termination by accepting your rent for the time after that notice expired. For example, the notice says to leave by the 17th of the month, but you paid the full month's rent in advance, which the landlord accepts. He should have immediately returned the overpayment beyond the 17th. The landlord waived the notice because, he wanted the money, and now he has to start over with a new notice. In another situation, if you still haven't moved out by the time the notice expires, you can offer a week's rent because, you don't expect to stay there for free. If the landlord accepts that money, he waives the notice and has to start over. So, if he continues to trial where he's waived the notice by accepting rent, you win the case. Here's a reason for eviction ripe for abuse. It's about what the landlord says he intends to do in the future. Landlords intending to circumvent the law may use this reason to disguise what they really intend to do, such as to evict a rent-controlled tenant to jack up the rent, or for a reason that the law does not permit, or to conceal a retaliatory eviction. It happens all the time because landlords think they're slick and that their tenants will never question it. Well, question it. The first question is whether the landlord has listed the property with a real estate broker to sell. With all the possible complications and knowledge of values in the real estate sale, hardly anyone does it themselves. If there is no listing, that's a red flag. You can ask to talk to the broker about a possible buyer and working out your rental terms during the sale. If he refuses, that's a red flag. Why wouldn't he let you help him sell the property? The next question is, when does he plan to sell? So that you can plan your move. If there's no time, it's another red flag. Why evict you now and lose the rent? He may ignore your questions and just file the eviction case, during which you can require him to supply that information and get into what you suspect his real reasons are. If you can show that he's probably not selling the property, but just using it as a reason to get around the law, you win that case. The next no-fault reason for eviction is where the landlord or a family member wants to move into the property. Seems simple enough. What could go wrong? The same kind of protection for the tenants as I just described for the sale of the property apply to this kind of eviction too. If the city or county you live in has a special ordinance that requires the landlord to pay you relocation assistance, it may require a permit to evict for that reason, provide help to find a new place to live, give you extra time to move, or other conditions and procedures. It might have a limit on what family members qualify. It might punish landlords who falsely evict for this reason. If the landlord fails to strictly comply with any of these conditions, you win that case. If the TPA applies to your tenancy, the same notice requirements and relocation assistance apply to you for this kind of eviction as well. As with the sale of the property, if the landlord's eviction notice does not identify the reason for eviction, identify how you are getting the relocation assistance, and the amount, which is at least 1 month's rent, exclusive of your security deposit, then you win the case on that basis. Within those protective laws, the question arises whether it is a family member. A brother from another mother probably doesn't qualify. If the title owner is a family trust, corporation, or LLC, it has no family members. The family of a corporation are parent and subsidiary corporations, not people. You can win the case on that basis because the people intended to move in are not the literal family of the owner. Really, they could just be new tenants willing to pay more than you. A related reason for eviction could be that the landlord is taking the property off the rental market, as he would to sell the property, in order to move in such people. That case would then be under the same strategy as the sale of the property we discussed earlier. Here again is the future intent of the landlord ready for abuse. Question it. Is the landlord moving in from his mansion to your little house? Who is the relative and where are they moving from? I had a case where the landlord claimed his sister was moving in, but she lived in Cuba and had no exit visa. If the landlord or relative is moving in, what preparations have they made to leave their current home, like a sale? If the landlord owns other rentals, why yours? See who the title owner is by getting a copy of the deed from the county recorder's office or a real estate agent friend. Is it a person or an entity? As with the sale-based eviction, if the landlord files a case, you can require him to supply that information and get into what you suspect his real reasons are. If you can show that he's probably not moving in himself or moving a relative in, and just using it as a reason to get around the law, you win that case. Next is the eviction for the landlord to demolish or do major construction in the property. The housing supply is aging, and property values change. It might be more profitable now to completely demolish the house you live in, build something new, and then sell it, or do major remodeling. For construction, the work has to be so extensive that you can't live there, and require more than a month to complete. The concept is simple, but there's more to consider to win the case. The same type of protective laws for sale, taking the property off the market, and moving in reasons apply to this type of eviction as well. The proper notice, procedures, conditions, and relocation assistance in the local ordinance and TPA provide the same basis for you to win the case if the landlord fails to strictly comply with them. A primary issue is whether the intended work comes within the type of major construction for which those laws permit the landlord to evict you. For example, in Los Angeles, there is a distinction between a temporary relocation and a permanent one, based upon what is planned. If the work will necessarily require you to vacate for more than a month, it can qualify for the permanent relocation assistance with a substantial payment to you. Otherwise, the landlord has to pay for your hotel, meals, and incidental expenses as a condition of getting the permit to evict you. If the work to be done does not require you to be out for much more than a month, and only temporarily, you could negotiate the terms. For example, maybe the work is for fumigating for termites, or removing mold inside the walls, fixing rotten flooring or a leaky roof, or installing new plumbing or electrical systems. Those can easily be done within a month if the workers stay on it. You can ask the city building inspectors how long work like that should take, and they can give you a pretty good estimate, so you can compare that with what the landlord or contractor tells you. You can get a copy of any work permits that the contractor has applied for from the records section of the City Building and Safety Department to see what the scope of that is. You can ask your landlord to give you the phone of the construction contractor, and if he refuses, it might be because you might learn the truth. If the contractor gives you a different answer than the building inspector or the permits show, Ask why it is that his estimate is so different. Your landlord may have told the contractor to lie to you, believe it or not. You just need to know whether your eviction is absolutely necessary. What's the harm in that? If the proposed work does not qualify as major construction, you can win the eviction case based on that. Whether you have the local or TPA protection or not, you can still negotiate with the landlord for your temporary relocation and return to the unit. Your negotiation leverage is that you can prevent him from coming in at all to do the work. You own the right to possession, and coming in without your permission is a trespass. You can tell the workers that they can't come in, and if they don't leave, you'll have the police arrest them for trespass, and you will sue their company. You have that much control. If the landlord refuses to negotiation, as will normally happen, he has to go through the eviction lawsuit, which can delay his planned construction for months or years, during which the government inspectors may fine him for failure to correct the defects. While he's fighting the eviction, he gets no rent from you, but has to pay the mortgage, insurance, property taxes, his lawyer, and other expenses out of pocket. The contractor who had scheduled this time and set up subcontractors to also show up during this time will have to cancel the job, leaving the rescheduling of the work for a much later time. If he really doesn't have major construction or another legal reason to evict you, you can win at trial on that basis. The total cost of all that on the landlord far outweighs what it would take to make you happy. If the landlord thinks like a businessman, negotiating with you is a far better idea. You can have a written agreement for your temporary relocation, where he pays for your hotel and restaurant expenses, returns your place clean as you left it, and protects your personal property from theft or damage. You owe no rent during the time of the construction work and are not responsible for any damage caused by the workmen. The date of your return is confirmed, and you get some extra compensation just for cooperating. What's wrong with that? Anything unfair about it? He just doesn't like the idea that you are calling the shots. But you are, because you can, and he can't do any better fighting you over it. In your check with the local building department, the permits applied for or issued will tell the real story, and if there are none, that's a red flag. If there is no contractor, that's another red flag. You want to see the work contract, and if they refuse to show you, that's at least a yellow flag. If there is no completion date, that's a red flag because the work contract must contain a completion date. If there is a contractor, you want to talk to him about your living there during part of the construction and your access to your personal property during that construction. It may be that all that's planned is cosmetic upgrades, where once you're out, the landlord will rent your place at a much higher price. If you can show that the work is not demolition or major construction, or probably not being done, or that the real reason for the eviction is something else, then you can win the case on that basis. Until 2020, the landlord could evict any tenant just because the lease had expired without giving a further reason or even a notice of termination. The TPA changed all that for those tenants to which it applies. If your building is at least 15 years old and you've lived there for at least a year, the TPA probably applies to you. Among the reasons for eviction under the TPA, mere expiration of the lease is not a valid ground. Curiously, refusing to sign a similar lease for the next year is a valid reason to evict you. If you refuse to sign a new lease at a higher rent or other different terms, it's not a similar lease and you don't have to sign it, and you can't be evicted for not signing it. If you're covered by the TPA, but the landlord tries to evict you just because the lease ended, you win that case. Even where the TPA or local ordinance doesn't apply to prevent that kind of eviction, you can use the law to extend your stay. If your lease ended mid-month, but you paid for the full month, the lease continues as a monthly tenancy and did not terminate. If your landlord gave you a notice during the last part of your lease to vacate by a date that is past the last day of your lease, the lease did not expire, and you have the same monthly tenancy. If you offer to pay for another month or so after the lease expires and the landlord accepts it, the lease is converted to a month-to-month tenancy. If you overpaid rent, either by too large a security deposit or by a lease starting mid-month where prorated rent was not properly applied, or late fees improperly charged and paid, you also have an argument that you're entitled to that rent credit and therefore entitled to those extra days after the lease expired. If the landlord tries to evict you just because the lease expired, but you have one of these defenses, then you should win that case. Landlord abuses of eviction have led to even more protective laws to stop or discourage them. A landlord used to be able to evict any tenant for no reason, just by giving a notice of termination. Landlords trying to get around the law, conceal a retaliatory eviction, or conceal an eviction not permitted by the law, used that notice. When asked why they want you out, they would simply say, "I don't have to give you a reason." And they didn't. But why wouldn't they tell you if they had a legitimate reason? Discrimination on the basis of sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status is one set of such illegal evictions. That list comes from the Unruh Civil Rights Act, Civil Code Section 51. The landlord never says that this is why they're evicting you, of course, but the circumstances can suggest that. You question the landlord as to their reason for eviction. You check with other tenants to see if they are treated the same as you are regarding the same issue. The landlord himself may not be discriminating, but if the resident manager is doing it, the landlord is legally responsible for that. Of course, you first have to show that the stated reason for eviction is probably not true, so the question arises, why the eviction if not for the reason claimed by the landlord? The facts showing discrimination put you over the top in an iffy situation, and you can win the case on that basis. Civil Code Section 1161.3 provides protection against being evicted or refusing to renew a tenancy due to a broad range of conduct. Domestic violence, sexual assault, stalking, human trafficking, elder abuse, dependent adult abuse, a crime that caused bodily injury or death, showing or using a deadly weapon, or a crime using force against the victim. I'll call these listed acts for short here. The tenant needs to provide the landlord with a police report, restraining order, or a statement identifying the situation as described in that law, identifying one or more of the listed acts. If the listed act was directed against you, your immediate family, or a household member, the landlord cannot evict you unless the person committing the listed act also lives there. If it is a listed act directed at other than someone living with you, such as neighbors, their guests, or apartment staff, the landlord has to give you a 3-day notice not to permit or to consent to the presence of that person anymore. If after the 3rd calendar day of getting that notice, if you keep inviting that person to visit, your eviction is permitted. For example, if you and your spouse are living together and have a dispute that turns to violence, or one of those listed acts, you can both be evicted. However, if you are living separately from each other, and the non-resident spouse does any of those things, such as during a child custody exchange, you are protected from eviction. If, in another example, if your friend comes to visit but engages in a listed act against a neighbor, and the landlord gives you a 3-day notice not to have your friend come around there anymore, if you tell him not to come and don't let him in, you can't be evicted if he returns to the building anyway. So, to win an eviction based on those kinds of things, you need to prove that any part of their case is wrong. It could be that the listed act happened, you reported it to the landlord as required, and the person who did it does not live with you. Or it could be, although the person does live with you, if he or she did not commit one of those acts, you cannot be evicted. It could be that you told your friend not to come around anymore, that you didn't invite them or let them back into your home, but they came anyway. In most cases, you may be the only real witness on the scene who can say what happened, particularly after the 3-day notice is given, and the other witnesses only heard things. You should win that case under the protection of Civil Code 1161.3. Civil Code 1942.5 is a special law that prohibits the landlord from retaliating against you for your exercise of legal rights. You have the right to complain about uninhabitable conditions, about the landlord's trespassing, about the noisy neighbors, or about the landlord's failure to do as the contract requires. You have the right to complain to the Building and Health Department, Fire Department, and Police. You have the right to use protective laws, obtain relocation assistance, and many other things. These are only examples because the list itself is huge. Exercising your rights comes down to actual conduct. The landlord cannot evict you, threaten to evict you, harass you, raise your rent, or other things where his intent is to retaliate against you for your exercising those rights. For example, if you ask the landlord to fix the heater and he ignores you, you call the building department, who makes him spend money fixing the heater, which cuts into his profits, and fines him $1,000 per day. He's angry for that, and he gives you an eviction notice for no reason. It's retaliatory. If he files the eviction within 180 days of your exercise of rights, he has the burden to show that it was not retaliatory. That means, if it's your word against his, you win. His retaliation may be disguised as one of the other types of eviction, even non-payment of rent. If you can show that his reason for eviction is probably retaliatory, you win the case, even if he otherwise had a valid reason. If you can show that his retaliation was malicious, that is, to punish you for exercising your rights, oppressive, that is, to scare you away from continuing to exercise your rights, or fraudulent, by lying to you in connection with his retaliation, you can also sue him for punitive damages, extra money to reward you for turning in the bad guy. If the landlord decides that he's going to try to evict you anyway, you can sue him while you are defending against the eviction. He thinks he's the hammer, but he never expected that he'd be the nail. You can sue him for retaliation, fraud and deceit, trespassing, unfair business practices, violation of the local protective laws and of the TPA, and other claims that may apply. You don't have to wait until you win the eviction case. In doing that, you want to stick to claims that are intentional misconduct, so that he can't just turn over your case to his insurance company to handle it. The insurance company will handle breach of contract, negligent, emotional distress, and personal injury, but cannot insure for intentional bad acts. That means that the landlord will have to pay out of his own pocket for his defense lawyers, and pay out of pocket any money judgment you get against him. After you win the eviction case, you can sue the landlord and his lawyer for malicious prosecution, which is trying to evict you knowing that they had no valid basis. You can record a notice of intent to preserve interest in the county recorder's office to preserve your rights to return to possession as against the new owner if you've been wrongfully forced out. That in itself may prevent the landlord from selling the property to anyone, or affect his ability to borrow money to do his construction work, stalling his progress in that as well. If you sue your landlord, his own lawyer will suggest him that the best move is to work it out with you because you have him over a barrel. He won't like that one bit, but that may be what it takes. You now know a lot more than your landlord does about all this, and maybe more than his lawyer does. You see how knowing key information and taking the right action can make all the difference in the outcome. We can help you with the specifics of your case, but at least you know that you have a case and what you can do about it. Don't sit on your rights, stand on them.